Welcome to The Explainer. Today, we're going to trace the incredible journey of the right to property in the Indian Constitution. And if you're a UPSC aspirant, you know this is an absolutely crucial topic.
So let's dive right in with a question. Is the right to own property a fundamental right, or is it just a regular legal one? Well, the answer has actually changed, and changed pretty dramatically over the years. This isn't just some dusty legal history, you guys. It's a fascinating story of a constitutional tug-of-war.
Okay, so let's rewind the clock. Back when the Constitution was first adopted on January 26, 1950, the right to property wasn't just some minor clause. No way. It was one of the original 7 fundamental rights.
Now, what's really interesting is how it was protected. It wasn't just one article, it was 2. You had Article 19(1)(f), which was just for citizens, giving them the freedom to buy, own, and sell property. And then you had Article 31, which was a much broader shield for everybody, citizens and non-citizens alike. It basically said the state can't just take your property unless it follows the law, has a real public purpose, and gives you proper compensation.
But here's where the trouble started. The new government had this big vision for a more equitable India. They wanted to carry out major land reforms, especially breaking up the old zamindari system. And this fundamental right, it stood right in their way. Every time they passed a land reform law, it got challenged in court, and this forced the government to make a big move, leading to the very first amendment to the Constitution.
So that brings us to the First Amendment Act of 1951. Now, this wasn't just some small adjustment. It was a really strategic move by Parliament to start chipping away at the right to property. They introduced 3 very powerful new tools to protect their land reform laws from being challenged in court. It was basically a 3-pronged attack. They added 2 new articles, 31A and 31B, and created this brand new thing called the 9th Schedule. The whole point of all this was to create a sort of legal safe zone for any laws related to agrarian and economic reforms.
So let's look at Article 31A. Think of it like a shield. It protected 5 specific categories of laws. So if a law was about, say, taking over zamindari estates or mismanaged companies, it was now totally immune from being challenged on the grounds that it violated fundamental rights like equality or freedom.
And then there was the 9th Schedule, which was introduced by Article 31B. The best way to think of this is like a locked box. Parliament could pass a law, stick it inside the schedule, and bam, the courts couldn't touch it. The judiciary just couldn't open the box to see if the law inside was actually constitutional. It was basically a get-out-of-jail-free card for legislation. But the story doesn't end there, not by a long shot. The next big chapter came with the 25th Amendment in 1971. This is where Parliament really doubled down on prioritizing its socialist goals over an individual's right to property.
Now, to get what happens next, you have to know about these 2 directive principles. Remember, these aren't rights you can demand in court, but they're meant to guide the government. And Articles 39, B, and C are all about creating a more equal society, sharing resources, and making sure wealth doesn't just end up in the hands of a few people.
And this timeline of Article 31C meant it perfectly captures the power struggle between Parliament and the Supreme Court. Parliament tries to shield its laws from the courts, but then, in the famous Kesavananda Bharati case, the Supreme Court pushes back, saying, nope, you can't take away our power of judicial review. So Parliament tries again, expanding the shield even further, only for the court to strike that down in the Minerva Mills case. It was a constant back and forth. Okay, so after decades of these amendments, these dilutions, these epic court battles, the Janata Party government in 1978 decided it was time to just settle the issue once and for all.
And what they did was dramatic. The 44th Amendment wasn't a tweak, it was major constitutional surgery. It literally took a scalpel and cut Articles 19(1)(f) and 31 right out of Part 3, the chapter on fundamental rights. Just like that, the right to property was officially demoted.
So, where does all that leave us? Let's break down what the right to property actually means in India today, because it's not a fundamental right anymore, but it hasn't completely disappeared either. The right was basically reborn, but in a different part of the Constitution, Part 12, as Article 300A. The wording seems simple, right? No person shall be deprived of his property, save by authority of law. But the implications are huge. It means the government can't just take your property on a whim. That's executive action. But, and this is the key part, it is not protected against legislative action. If Parliament passes a proper law to take your land for, say, a new highway, they can do it.
And this right here is the bottom line, the real downgrade. For your exams, this is absolutely crucial. When it was a fundamental right, you could go straight to the Supreme Court if it was violated. Now you have to go through the High Court first. And maybe most important of all, that guaranteed right to compensation, it's gone. Now whether you get compensated depends entirely on the law that's being passed.
But hold on, there are a couple of really important exceptions you need to know about. These are kind of like fossils left over from the old system. Even today, compensation is still guaranteed as a fundamental right in two specific situations. One, when the state takes over property from a minority educational institution. And two, when it takes land from a small farmer who is farming it themselves and is within the legal landholding limit.
And that brings us to the end of our explainer, leaving you with a big question to chew on, something that's perfect for your mains exams. Was this whole long constitutional journey a necessary step towards building a more just and equitable society? Or was it a slow erosion of individual freedom, creating a state that's just too powerful? It's a debate that's still very much alive today.